Divorce is a process that creates change in the life of not only the couple involved, but the children and the extended family as well. For many, the decision to file for a divorce is a tough one, and it can be a bit intimidating as you are unfamiliar with the process and how the process will not only affect you, but affect your children. Whether you've been married for 20 years or a year, it's important to know what the process looks like. Ideally, it would be nice if the transition was quick and smooth, and if everyone agreed and felt as if they were treated fairly and with respect. If you are going through a divorce, it's important to speak to an attorney to figure out what your options are. When you and your spouse prefer to deal with the divorce outside of court, resources on collaboration and mediation can guide you through an inexpensive, cooperative separation process. Unfortunately, some divorces end after years of being in court where both parties leave very angry and very bitter. But there are steps to take to assist in educating those who are seeking divorce to help it to be a smoother transition. One of the first steps in getting a divorce is to file a petition with the court asking for or requesting for a divorce. The petition will state the reason for the divorce. The reason for the divorce can change, and that depends on your location, the location in which the divorce is taking place. Some states will allow a couple to receive a divorce filing irreconcilable differences. It's important to know the laws of your specific state and find out what is allowable. The next step is for one person to file a petition to the court for the divorce. A copy of this petition is then given to the other party, who can either represent themselves in court or they can also hire an attorney. The petition can be filed by another party, and this can be done in the spouse's home, their place of employment, or any other location. Once the party receives the petition, they can either dispute it or they can accept the petition and decide to move forward. The spouse can disagree under the topics of property, support, whether that is spousal support, custody of the children, or any other issues that they choose to address. The couple can negotiate if they do not agree on the petition. And the court may schedule a meeting to go over the settlement. And this meeting is to ensure that both parties are moving towards the resolution of the issue. If the party disagrees on child custody and visitation, the court may also order mediation. And mediation may involve a social worker or a court-appointed employee to assist in the best interests of the children. Other issues that may need to be negotiated are property division or any spousal support. If there is no resolution available, the couple will have to take this case to trial. And the trial is typically longer, they cost more money, and the results aren't guaranteed for either party. In the end, the court awards an order of dissolution, the dissolution of the marriage, and this order explains what the decision of the court is to divide the awarded property, debts, custody, spousal support, or any other issues. The couple could decide on their own dissolution, and then they can subsequently provide that dissolution to the court for approval. Child custody is also not an easy topic, but it's important, again, to educate yourself on the custody laws of your state. There are different forms of custody. The first being physical custody, which is the right to physically have your child with you after the divorce. And this can be granted to one parent or both parents. The next is joint physical custody, where the child is physically with both parents. And that could be 50% of their time spent with one parent, 50% of their time spent with the other, or an arrangement which is made, which includes alternating weekends or months or holidays at each parent's house. Another option is sole physical custody, where the child is permanently with one parent. and the child could have visitation. The parent could have, visitation with the child, but the child's permanent location is with the other parent. The parent without custody can petition the court to ensure that they receive their fair amount of visitation with their child. The parents can also have legal custody, which means they are able to make the decisions in regards to the child's upbringing. So that would be in regards to their education, medical care, religious instruction. And the couple can attend a mediation where there is a neutral third party that helps them to settle disputes that they have between them. And once there's an arrangement, the mediator will prepare a written agreement, which will be finalized by the court. In negotiation, the court seeks to meet the need of the child. And this is accomplished by considering the relationship the parent has with the child, the location of the parent, the child's preference, financial, emotional support, the age of the children, and if there is any history of abuse or neglect. Each parent should consider receiving additional support via a professional to learn how to navigate through this new process. The truth is that divorce, it not only affects us, but it affects our children. And it's important for the children to know that, despite the dissolution of the marriage, that they are still a priority and that they are still loved. I believe it's important to communicate, as long as it's age appropriate, to communicate that, this didn't work out, but you are still loved. The AAMFT suggests that an MFT should seek consultation if they are uncertain about a specific topic with their client to ensure that they are practicing ethically. They should refer the client if there is an issue that is out of their scope or they feel that they are not benefiting the client while in therapy. As always, confidentiality is key unless we are dealing with a client who's a danger to themselves, a child, or we're discussing elder abuse. There are situations where a client is subpoenaed by the court. And this can also be scary, but it's important to know, what to do in this situation. If a subpoena arrives from a client's attorney without a signed client release form, the therapist should check with the client and not with the attorney before releasing the documents. This is important because before releasing the records, you must obtain written authorization. The therapist must personally confirm with the client and obtain written authorization. Please remember that privilege sometimes does not apply and privilege is sometimes waived. It is not the duty of the therapist to determine what applies and should always obtain written authorization or a court order. Once a signed authorization accompanies the subpoena and the therapist believes the material may be clinically or legally damaging to their client, the therapist should discuss these issues with their client before they release anything. If possible, the therapist should not provide a summary of the records in lieu of the records themselves. This is very, very, very important because, again, the process of receiving a subpoena from the court could be a scary process, not only for the therapist, but for the client, because they may have disclosed some information while they were in therapy that they don't want their significant other to know, not only their significant other, but they don't want the court to be aware of this information. And it's important to ensure the safety of your client while they are going through this process. Again, this process can be quite overwhelming, and it's important to seek counsel to assist in making this a smooth transition. And keep in mind that this transition is not necessary for the transition to just be smooth for the parties involved, but the fact that there are children involved, and outside of children being involved, there is a extended family who is also affected by the dissolution of the marriage. So it's important to remember that this process does not only affect your client, but there are other systems that are affected by this process. And the goal is just to make sure that that everyone is treated fairly, that everyone is treated with respect, and in the end, that everyone can move on into a new chapter in their lives. Thank you so much.